This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
Now, I have the pleasure of introducing Mikebaumages. Mikebaumages is a mediator, arbitrator, and discovery referee with ADR Services, Inc. As an AV-rated attorney for over 49 years, Mike specialized in business, employment, real estate, litigation. For 7 years, Mike had what he says was the best lawyer job in the world as general counsel of the Ocean Pacific surfwear clothing brand. Mike's experience also includes mediating more than 500 cases and presiding at more than 1,000 mandatory settlement conferences as a temporary judge in the Orange County Superior Court. And some interesting facts about Mike. For more than 25 years, Mike has been the lead astronomer for the reserve at Rancho Mission Viejo. Mike and his wife, Mary, live in North Tustin and have been married for 52 years. They have 8 grandchildren who live nearby, and Mike is also an expert in Moreton Bay fig trees. So Mike, passing it to you.
Thank you, Hayward. If anyone would like to know what a Moreton Bay fig tree is, please feel free to text me or email me, and I'll definitely send you a lot of pictures. Hayward, is my picture up there? Because all I see is your name at this point. So
your picture is on screen.
Okay, good. Thank you. Good morning again. I'm Mike Balmages, and good morning to all you attorneys out there whose last names begin with A to G. I am one of you, and I'm also attending these talks today, and will attend the ones on the 19th also. So Hayward mentioned this is actually my 50th year of practice. I just passed my 49th year anniversary. You would think that by now I would know everything and wouldn't need MCLE, but I keep finding out on a daily basis how much I don't know. I'm going to talk today about settling cases and some frequent issues that affect that process. Mostly, I'm going to discuss that in the MSC and mediation settings. So let me see if I can share my screen right now, actually. Hold on a second here. So my PowerPoint is now visible. I'm glad to see that. So I was involved. I started practicing right out of law school in Orange County in 1972. And I was involved in a lot of settlement negotiations, including mediations and settlement conferences. Early on, that was mostly settlement conferences and lawyer-to-lawyer negotiations, because mediation had not started to take off until the 1980s or 1990s. And you all know of the unwritten rule of professional conduct that says when a lawyer gets old, he or she must become a mediator. So I got old about 20 years ago, and I took some mediation courses at UCI and started doing mediations in connection with my business litigation practice. I did a couple of hundred. In 2017, I retired from the practice and went in full-time with ADR Services, Inc. So I've done about another 300 plus mediations since I've been there. In addition to that, Hayward touched on this, Orange County has a very robust temporary judge program, including having the temporary judges do the MSCs. And I am the world record holder in that program, having done more than 1,000 MSCs, all for free. In fact, I got a lifetime award for doing this. So if you are or want to become a mediator, I highly recommend you start doing MSCs as a TJ if your court has such a program. There is training required and certification, but the experience is invaluable. Also, another recommendation is to find out whether there is a dispute resolution program program in your county. That's a state-funded program for alternative dispute resolution. There's a 40-hour training course, and once that is complete, you get to do community mediations. In Orange County, you also get to do small claims mediations. And those, I went through the program a long time ago, and those were the first mediations I did. A few hundred small claims mediations. They test and hone all the skills you're going to need to mediate regular civil lawsuit mediations. So I've been a settlement neutral about 1,500 times, and that is the source of what I know about settling cases. The materials that you should have gotten today or are available today include an article I wrote last summer for the Orange County Lawyer, which is the OCBA's magazine, and the PowerPoint for today's talk.
Mike,
The article, which a copy of the first page, is
sorry
up
to interrupt
here.
you, Mike.
Yeah, go ahead.
Would you mind clicking on Start Slideshow, please?
Okay, I need to click on that. So, all right, so I go back to this. And I start slideshow over here. Play from current slide. All right, so is that not performing as it should? All right, there we go. All right, so I gotta minimize this a bit here.
Perfect.
All right, so that should be up there. All right, great. All right, so let me go back to the slide that I want to start at. And this slide, this barriers to settlement slide kind of, well, let me go back to the story that I published in the Orange County Lawyer magazine. I want to talk about that briefly. That article is Pay Now or Pay Later. It's a mediation story and describes a very common phenomenon where relatively early on an offer is or demand is made and completely rejected. The parties then spend the next 3 months to a year or so spending hundreds of thousands of dollars litigating the case and then settle it for about the exact amount that was initially offered. 2 weeks ago, I settled a series of related cases that I had unsuccessfully mediated about 9 months ago. The total money that changed hands was about $3 million, the same $3 million that was on the table at the mediation. The only difference was that the parties had spent an additional $400,000 in fees and on experts during those 9 months. The PowerPoint is extensive in the sense that it covers way more topics than we can possibly cover today. I want to pick some highlights to talk about, but feel free to ask either via email or through the question and answer about any of the other topics today or afterwards if you want to call me or email me to discuss them. I welcome your input. This is a science. This is not a science, excuse me, it's closer to an art, but a very abstract art. It's more like guesswork. All right, this barriers to settlement slide, I want to talk about this. Actually, we could do a whole discussion on just this one slide. It would be better if instead of $100,000, the demand here was $1 million. Of the many, many MSCs and mediations I have done, the single most defendant initial offer has been $1,500, just ahead of waiver of costs. And this is kind of irrespective of what kind of case it's in. So what do we have here? We have, according to the plaintiff or the defendant, we'd have a bad faith demand. It's higher than their prior demand. I told them we'd never go to 6 figures. We have, from the plaintiff's point of view, a bad faith offer. It's lower than their last offer. Why did they even want mediation if they weren't going to offer anything? So the next round, when the plaintiff drops to $75,000 and the defendant comes up to $3,000, we've dropped $25,000 and they've only come up $1,500. Conversely, we get from the defendant, we've doubled their offer and they've only come down 25%. So let me go to the next slide here. So, oops, one slide too many. Some reasons why plaintiffs and their counsel do not want to settle. And so there's a list of the reasons I hear all the time and I see all the time. I'm not going to discuss all of them, but I will some of them. So I want to make sure that he or she never does this to anyone else again. What I tell the litigants when I hear this is that in very few cases will the result of your case change anything about how the company or they, the other side, treat other people. Be here to settle your case, not a future case. We must go to trial to maintain our credibility. You hear this from plaintiff firms. This comes from counsel. That's great, but what about this client? You're not litigating your firm's credibility. You're litigating this client's claim. Now, do I really say that to counsel this directly, i.e. your responsibility is to your client, not to your firm? Sometimes in a private context, sometimes in front of their clients. More frequently in MSCs than in mediation where they are paying customers, and there I try to be a little bit more tactful. We have too much invested in this case to settle. I hear that all the time. Too much in cost, too much in fees, too much in time. Yes, yes, that may be true. Those are sunk costs. They've been spent. Also, this ignores the fact that you are going to spend more time, money, effort, everything to go forward, and you could lose and recover nothing, or you could win but not recover enough to cover your sunk costs. Again, sunk costs are sunk. Generally, they should not drive settlement, even if you might recover attorney's fees and costs if you win. All right, let's go on to some reason why some reason why defendants and or the counsel do not want to settle. My associate needs trial experience. You don't know how many times I've heard that. I mean, dozens and dozens of times. And really, is that what this case is about? Does your client need trial experience is how I respond to that. I'd rather pay my lawyer than pay that jerk anything. Well, the one guarantee, and I tell this to the litigants, the one guarantee I can make to you is that your lawyer will bill you for this. And if you lose, you're not only going to pay your lawyer, you're going to you'll pay the plaintiff, and you're going to pay the plaintiff's lawyer. My firm's reputation. We have a lot of cases with this plaintiff's counsel, and we can't let them think that we will roll over for them. Again, what about this client in this case? Go to the next slide. Trouble from both sides. So I am often called upon by lawyers prior to a mediation to tell their client bad news that the lawyer doesn't want to. I'll get a phone call before the mediation. The lawyer will ask me to let his client know that there are problems with the case. There's a weird phenomenon that happens where I get such a request from counsel, and when I find it to be a valid request, I'll discuss the facts of the case and the problems. I try at the mediation to inform the client of the problems with the case. The same lawyer, the one who's asked me to inform his client of these problems, will disagree with me. Not in a mild way to show that he or she is on the client side, but really argue with me to the effect that he or she canceled out the message that counsel wanted me to deliver. At other times, the lawyers just forcefully argue with me about the merits of the case and won't admit there's any chance they may not win. The room where it happens. In the mediation courses I took at UCI, I learned two things that I still remember. The importance of where you seat people at the table, and I mean literally, not metaphorically, seat them at the table. And this advice turned out to be completely irrelevant and wrong information. For example, we were told that you should seat the plaintiff and defendant on the same side of the table so they are not sitting in opposing positions. One of the reasons that this advice as to where to seat everyone at the table is meaningless is that they are rarely at the same table. I rarely have joint sessions. I only have them if all counsel want them, and they usually do not, and there is a really compelling reason to have them. And most of the mediators I talk to seem to agree about this, at least if they are Southern California mediators. This seems to be a SoCal phenomenon. In Northern Cal and the rest of the world, it appears that joint sessions are common and usual. As a lawyer, I did not like joint sessions. They were always awkward and uncomfortable, and I felt they did little good. The weirdest joint sessions I ever had were with the same mediator. This is back in the 90s on a series of related cases. In each case, the mediator asked the plaintiff to tell his or her side of the story. And when the plaintiff was done, the mediator would retell the story in a histrionic voice with great emotion. The mediator would then repeat the process with the defendant. I found this process gross. I mean, it was remarkable that the mediator, who took no notes, could remember everything that was said by the plaintiff and then the defendant and repeat it in this kind of acting method, but it was just very annoying. The second thing I remember from my mediation courses is that the hardest person to settle with is the person who is not in the room. The process works. The dance, or whatever you want to call it, that we do in mediation works, whether it's bids or counter bids or whatever, but it only works for the people who go through it. Now, here's another difference for me in my roles as an MSC judge or as a mediator. As an MSC judge, I can order people to be there. As a mediator, I cannot. This is a problem more with defendants, entity defendants, governmental defendants, and insured defendants than it is with plaintiffs. Very often, the representative sent is not one with the unlimited and unconditional authority to enter into a settlement. And I'm going to take a look at some of the local rules here. These are Orange County local rules, local rule 316. It says that an appearance by an attorney claiming to have settlement does not satisfy. If the plaintiff or defendant is an entity, all persons whose consent is necessary must be present, and each insurance carrier must have a representative present who has the unlimited and unconditional authority to enter into a settlement. Let's take a look quickly at the LA rules and not read the whole thing, but attendance requires all persons whose consent to effect a binding settlement must be personally present, including those persons. These persons must have full authority to negotiate and make decisions on settlement of the case. California rules of court, our next slide here. Trial counsel, parties, and persons with full authority to settle the case must personally attend. And finally, the central district's rules on their mediations. Each party shall appear at the mediation by a representative with final authority to settle the case. Representatives of insurers with decision-making authority are required to attend, and each party shall be represented at the mediation by the attorney who is expected to try the case. The most frequent problem I encounter here is with trial counsel and insurance representatives. Trial counsel, often they send an associate or someone who is not going to otherwise be trial counsel or involved in the trial of the case. Trial counsel is often, quote, engaged, unquote, elsewhere. Nobody seems to know where, but they're sure he or she is engaged. Insurance reps are rarely the right reps at MSCs. Very often, the insurers will send an independent outside adjuster who is not an employee of the insurer. More often in mediations, the insurance companies will send the right adjusters. In the old days, doing MSCs in the Orange County Superior Court cafeteria, I could tell whether representatives or counsel had the requisite authority, because those who didn't would run down the hall to a payphone. We'd have a discussion, they'd take off to where the payphones were. Then came the cell phone, and I'd see them across the room in the cafeteria after every offer demand on the cell phone. And now you can tell who doesn't have authority because they are texting, even while you're talking to them. They're texting back to their supervisor or to the trial attorney. As an MSC judge, I will often figure out by looking for these clues and just plain asking them. I mean, I ask all the time whether an adjuster has to report to somebody or get a consent to somebody, but I'll often figure out who the appropriate lawyers and representatives are and order them to be present that day sometimes, if they're close enough, or at a continued hearing. Counsel will almost always argue with me on this and say that they, counsel and the representative, have full authority, even right after counsel and the insurance rep has told me that they do not. I want to go back a second to the LA local rules on settlement conferences, and I want to take a look at the paragraph 4 down here. Plaintiffs' counsel must ascertain whether there are liens which bear on a potential settlement, and if so, request the claimants or the representatives to attend the settlement conference or be available for telephone communication during the conference. I did not know of this rule. I never read this rule until I prepared for this presentation. And in my more than 1,000 settlement negotiations, MSCs, and mediations, I have never had lien claimants present or requested to attend the settlement conference or to be available, requested to be available for telephone communication during the conference. Usually it's just the opposite. Plaintiffs' counsel won't even try to contact lien holders until the settlement amount is agreed upon, and they tell me that they want to make the settlement contingent upon getting an adequate settlement with the lien holders. Often they don't even know if they're lien holders. I ask about lien holders as the negotiations go on, and when I learn that counsel doesn't have a handle on it, I just ignore that for the time being and try to get to a settlement number anyway, and then worry about the liens. Now, don't get me wrong, there are plenty of plaintiffs' counsel that are very prepared on liens, but I think it would be a great idea if this court rule ended up as a law requiring counsel on both sides to come to MSCs and mediations fully prepared to discuss and resolve the liens. I call this the Hamlet Dilemma, to be or not to be, to settle or not to settle, paralysis by analysis, overthinking mediation strategy. And there are lots and lots of things that counsel often spend a lot of time ruminating over and discussing with me. I often respond with, hey, you're overthinking this, just give me a number. I'll touch on a few of them. I don't want to signal, we're moving up too fast. I hear these a lot. There is much hand-wringing analysis as to what the next bid or offer should be. It goes on and on. I'll often suggest a number, but that usually leads to more overthinking. They'll tell me, no, I can't go up there, that's too fast or whatever. I tell counsel, just give me a number. There's nothing in a number, this number, that requires you to go up or down at any set rate. You can always slow down, you can speed up, you can change course. But after spending an hour or so with counsel trying to get a number, just give me a number. Hang on one second here. As to last, best, and finals, last, best, and finals are rarely, if ever, last, best, or final. I like to say that I've never met a last, best, or final that really is last, best, or final, but occasionally you do. I'll get an offer from the defendant and they'll tell me, we'll go to $60,000, but that's our last, best, and final. That's it. And I said, do you want me to tell that to the other side? They say, yes. Okay, I do. I will tell that to the other side. Plaintiff will then tell me, well, here's my last, best, and final at $75,000. You tell them that. The case will settle at $65,000. This just happened in mediation on Monday, where I got a last, best, and final demand of $180,000. This was in a mediation that was set for half a day, 4 hours, and ended up going 9 hours. And in about the 8th hour, I got a last, best, and final demand from the defendant, from the plaintiff, $180,000. I then took that to the plaintiff and I got a response. I got a last, best, and final offer of $135,000. The case settled about an hour later at $160,000. I don't want to bid against myself. This I also hear a lot, and I often hear it from both sides at the same time. Well, they haven't responded to our 998. So the ball is in their court. No, take that to the other side. Nope, we told them we would not consider anything less than $100,000. So they've got to go there first. The ball's in their court. Counsel can be quite stubborn about whose turn it is. I go back to you're overthinking this. Just give me a number. There's going to be nothing that's not going to hurt you in any way for you to make the next bid. Brackets are another challenge. I am not a big fan of brackets, and I tell lawyers that when they suggest them, but sometimes they don't listen, and I deliver their bracket to the other side, who almost always responds with a counter bracket, and it just turns into a bidding of bracket midpoints and gets way overthought. Some more issues that are overthought. We've talked about most of these that are on this list, but I will mention one or two of them. We don't want to waste your time. I hear this all the time, especially at MSC's counsel. And this is often the trial counsel, who's a very experienced lawyer, very important lawyer, shows up, and the first thing that lawyer says to me is, I don't want to waste your time. This isn't going to settle. I generally respond with, it's not a waste of time. I'm here for the morning anyway. And then we go ahead with the mediation regardless of the lawyer telling me, the MSC, regardless of the lawyer telling me it's not going to settle. The other thing I get, again, at MSCs, is a lawyer who shows up for the 9 a.m. MSC and tells me he's got another appearance at 10 a.m. in another department or in Norwalk. Seems to be always in Norwalk. I generally do not take kindly to that as an MSC judge. So an issue that deserves its own slide and actually probably a whole hour or more by itself as a barrier to settlement is attorney's fees. Attorney's fees, as you are all well aware, are often the driver of settlement negotiations. As, for example, in ADA cases, or wage and hour cases, or FEHA cases, or in many, many other cases with attorney's fees clauses. But they impact in other ways. I often have counsel, particularly plaintiff's counsel in business litigation, absolutely sure that the case is not settling because defense counsel is being paid by the hour to litigate. And there's no way that defense counsel is going to give that up. And I have many accusations of bad faith along that. This was not my experience as a lawyer. I did not settle a case because I wanted to continue charging fees. I was too busy for that. If I could get a good settlement, I fully encourage it, even if it meant I would lose the client or at least work on that case. Truthfully, that seems to be what I observe with lawyers. They don't scuttle settlements just so they can keep billing, but I hear this all the time from plaintiffs' counsel. 3 constituencies. I have this discussion all the time also with defense counsel, but mostly with their clients. You don't have to settle today. You don't have to settle this case today. But if you are going to settle today, there are 3 constituencies you've got to take care of, that we've got to take care of on the other side. We've got to get some money to the plaintiff. We've got to get some money to the plaintiff's lawyers, as distasteful as that may be to you, and we've got to get some money to cover costs. Plaintiffs, on the other hand, tend to be very supportive of this. They will reject a defense offer that will take care of them if it doesn't also adequately take care of the lawyer. I've run into that many, many times. So this brings me to 3 irrelevancies. In addition to the 3 constituencies, I speak to litigants about these 3 irrelevancies: fairness, justice, and equity. And I say to them that really what we're here today doing has very little to do with fairness, justice, and equity. I say to plaintiffs, if you do get an offer, I'm not going to tell you that you ought to accept it because it's fair. I don't know what's fair, but I might know what's smart, and that's what I will advise you on. You got to listen to your lawyer. He or she knows way more about this case than I do, way more about the law, way more about the situation. But if I think there's a smart offer that you ought to accept, I'm going to tell you that. Our goal here today is smartness. And I emphasize that over and over again throughout the negotiations when counsel or the litigants go back to, well, that's just not fair, or they start running through the facts again to explain to me why the case should settle at a certain number. And then I remind them, we're not here to talk about fairness. That's not what's going to happen today. I say to them, I agree it's not fair, but it would be smart. The first time I remember doing this was at an MSC many years ago, where the plaintiff was a now 18-year-old woman who was suing her former elementary school teacher for molesting her. So the plaintiff had matured, the statute of limitations hadn't run, and she filed this suit. Her teacher had been convicted of the molestation and had served time, and now many years later was being sued. We were in the 3rd floor of the cafeteria in the Orange County Superior Courthouse, where many of the settlement conferences take place. And the teacher refused to come there, and instead was up on the 6th floor because there was still a restraining order against the teacher coming within so many yards of the plaintiff. I remember going up to the 6th floor to meet the defendant and to talk to her. And I told her what the demand was. She told me, she went through the story. She told me that she did not molest a student. She was wrongfully accused and wrongfully convicted, and she was crying this whole time. I told her that I was not going to tell her that it was fair that she settled, but I thought that it was smart that she settled this claim. She would otherwise have to relive all this, go through a trial, go through all the unpleasantness of this again. She seemed greatly relieved when I told her that I'm not going to tell her it's only fair. She told me that everyone was telling her how fair it was for her to settle, and I was the first person who did not say that to her. She settled the case. I remember another case where I took out a piece of paper off my legal pad, and I wrote on it, "This settlement is not fair." I dated it and signed it and gave it to the defendant, and she settled. I gave this talk or a similar talk to a law firm yesterday, and at the end, one of the lawyers who had attended Pepperdine's mediation program asked if equity played no part in my considerations in trying to settle cases, if I viewed settlement as a purely economic transaction. I answered, that's correct. No, equity does not play a part. But then I backtracked a little bit and said, well, when I talk about smartness, I also talk about non-economic things such as how difficult and unpleasant litigation is, how time and life invasive it is, and how rarely satisfying it is. But really, I don't work towards fairness, justice, or equity. I do not pretend to know what's fair in a case. I haven't lived it. I do not know all the evidence. I do not know who's telling the truth, who's lying, who's not. And the same thing goes for equity and justice. I tell the parties that if they're looking for justice, they should go to trial. Then by definition, they'll get justice. They may not like it, but it will be justice. frankly, when I tell the parties that any settlement will not be fair, just, or equitable, they seem relieved. It takes a great burden off of them. My promotion of smartness as a goal is not a new one. This is a picture of a plaque I got from the Daily Journal, a very expensive plaque I got from the Daily Journal of their profile on me. And you can see the title is Smartness is the goal. And that's been what I've been talking about for a long time. All right, so here's a list of more things to talk about. Some of them we've already mentioned, and we're not going to talk about all of them, but I will go through some of them. Bottom lines and top lines. Everybody fibs about these in mediation or settlement conferences. And I used to not even ask because it was just an unreliable game playing number. They play the mediator or the MSC judge as much as they play anybody else. Now I do. Sometimes I do ask about them, and I preface it with telling counsel, look, I know that everybody fibs to me about bottom lines or top line, but give me an idea. Just fib to me a little bit so I can figure out if we can get something done today. I usually don't do that early on. I do that in the one I had on Monday that settled at the $160,000 with $180,000, $135,000 last, best, and finals. I think that when I asked that to plaintiff told me with their little fib that their bottom line was going to be $200,000. And if I remember correctly, defendant told me that their top line was going to be $115,000. Remember, this settled at $160 after I got last, best, and finals thereafter at $180 and $135. So everybody does fib about them, but I asked them to give me a little bit of help, give me some idea where they can go. Money talks, and that's cash I'm talking about, literally cash. A bag of money works wonders, and as I said, I'm in actual cash, and I've seen this done and work well in ADA cases and employment cases. I recall an ADA case that I was doing where I don't forget what the settlement demand was, probably around $15,000, and plaintiff or defense counsel said, we'll pay them cash right now. We'll sell it for cash right now. I said, well, how much are you talking about? Defense counsel opened his wallet and had about $5,000 cash in his wallet. His client had about $3,000 cash in their wallet. And they gave this to me and they said, here's $8,000. You take this $8,000 into that plaintiff and tell the plaintiff that he can have this right now. The plaintiff took it. Cash works wonders. I've also seen it done in employment cases, usually in harassment cases, discrimination cases, ones that I would say did not have much merit to them. And I've seen $25,000 in cash brought to a mediation and just settle a case right there. I've seen that more than once in that same range. I'll tell you a quick story on that, a $400,000 cash story. I had a sexual harassment case that was a very egregious one where I represented the defendants. They had been represented by a prior counsel, and the defendants were bad actors in this case. With prior counsel, who was a colleague of mine, a former colleague of mine, they had offered $1.4 million to settle. So you get some idea of how bad a case this was. My colleague was disgusted with these people. She asked me if I would defend the case, and I said I would. We ended up with a mediation at one of our competing mediation firms. And I thought about the $1.4 million offer. And this is where I was starting to form my cash is king kind of concept. And I figured out a number. I asked them, the defendants, to bring $400,000 in cashier's checks to the mediation. And they did do that. So when the mediation started with a retired judge who I knew very well, was a friend of mine, the initial demand was something like $2 million, and we came in at $250,000. This outraged everybody. It certainly outraged the plaintiff, who said, you guys had offered $1.4 million. What's this all about? This is bad faith. The judge was kind of upset with me also. And as the mediation was about to end, I took out the $400,000. I was in with the judge alone. I took out the $400,000 in cashier's check and handed them to the mediator. I said, the plaintiff can walk out of this mediation today with this $400,000 in hand. He said, she's never going to accept that. I mean, you guys had offered 1.4 million. This is $1 million less than that. There's no way this is going to take place. I said, well, call counsel in. Counsel came in, and I told counsel, your client can walk out of this mediation today with this $400,000. No trial, no 2-year wait, no possibility of losing, all that kind of stuff. She took it. So that story, as much as any, convinced me how cash is so important and is king. Now, I've not done that very much. That's a case in which I was counsel, but I have seen it a few times in mediations where cash has solved the case. No good deed goes unpunished. The litigants like hearing this. It seems to validate their angst about the whole process. It seems to reaffirm their good behavior in the situation. This happens a lot in employment cases. I've seen it a lot in wage and hour cases where the defendant will tell me, well, wait a minute, this employee told me that he wanted more work, and I told him I couldn't afford to give him more work. I just couldn't afford the benefits on that. And he said to me, don't worry about it. You can pay me less than minimum wage. You can pay me in cash. I'll work a few extra hours a day. I really need the money. And I did that. And look, and now he's suing me on this. That's when I raised the no good deed goes unpunished, and they pick up on that immediately. And completely. As to settlement agreements, I want to just briefly discuss a little bit about settlement agreements. In my introductory email to counsel, I suggest that they talk about settlement agreement terms and bring a template to the mediation. This is rarely done, unfortunately. Occasionally it is, and it depends. PI defense firms will often have pretty standard forms that they can call up, but they usually do not speak about them in advance. Occasionally, more than occasionally, on many occasions, I have mediations or settlement conferences where counsel have opposed each other on numerous occasions, and they know what the settlement agreement is going to look like. But many times there's been no discussion of the settlement agreement. So the biggest areas of dispute tend to be releases, extended releases, confidentiality, non-disparagement, and liquidated damages. As to releases, the biggest issue generally defense counsel volunteers to prepare. They're the ones paying the money. They volunteer to prepare the releases, and they make the releases one-sided, and plaintiff's counsel will come back and ask for a mutual release. And this sometimes is a point of contention. We sometimes hammer that out at the mediation or the settlement conference. Other times it's a post-mediation thing that I get involved in. I get a call from counsel saying, we're arguing about this, you got to help us with this. Confidentiality is another thing. Now, there are some new statutes, relatively new statutes, about certain things that you can't keep confidential. But other than those, confidentiality, defendants almost always want confidentiality. Occasionally, plaintiffs don't want to agree to that because they want to be able to tell the world their story. Almost always, this is not a deal breaker, and the plaintiffs relent. And they'll sometimes, mutuality is an issue here too, because plaintiffs will sometimes ask for mutual confidentiality, going both ways. Generally not a deal breaker. Non-disparagement. So again, defendants will ask that they not be disparaged, and plaintiffs will generally agree to this, although occasionally they're reluctant to. Again, they want to tell their story, and they want to make sure that telling their story is not going to be a breach of some agreement, so they won't agree to it. Generally not a deal breaker, and generally plaintiffs will want to make that mutual also. So liquidated damages. Now I'm talking about liquidated damages in the context of damages for breach of the confidentiality, breach of the non-disparagement, and there used to be numbers put in there, sometimes 10,000, 15,000, sometimes per incident, sometimes not. Usually they were pretty punitive looking kind of thing. That was more frequent. I'm not seeing that as much now as I used to see that. Right now, I'm not seeing defendants demand liquidated damages for breach of the confidentiality and all that. And my experience in real world is, in terms of confidentiality, is nothing ever stays confidential, and the amounts will get out anyways. But people do argue about these and demand these. When I was going to tell a story about, and I will tell a story. When I was a general counsel at Ocean Pacific, this was back in the 1980s and early 90s. We had agreed upon, and this was before there were cell phones, or if they were rudimentary, there were no text messages. we had a board of directors meeting, which I was at as general counsel, in which we discussed settlement of a lawsuit. We took a break in the meeting, and during that break, I got a call from our licensee in Australia who knew what the amounts we were talking about were. And how that happened, and prior to cell phones and prior to email and prior to text messages, I don't know, but that helped convince me that nothing ever remains confidential. As to MSJs pending or MSAs pending, these tend to cut both ways sometimes. A pending MSJ or a pending MSA, usually by the defense, sometimes by the plaintiffs, but usually by the defense, often means that the defendant will only pay a nominal amount to settle the case because they are 100% sure that they're going to prevail on the MSJ or on the MSA, no matter how much time I spend talking to them. Now, if this is a settlement conference, what I will often do is just continue it. Okay, you've got your MSJ pending, and it's going to be heard in 3 weeks. Why don't we kick this off for a month or 5 weeks, and we'll reconvey at that time. And sometimes in mediations, I suggest that too. Defense counsel the defendant is just not going to come up with any money at this point because they are going to win that MSG. On the other hand, sometimes an MSJ pending or an MSA pending can further settlement. If the opposing party has not yet prepared the response, hasn't done all that work to go through and pay for all that work to go through to respond to the MSJ, sometimes, and if they think they're going to lose the MSJ, which they rarely ever do, that will help move towards settlement. Even more to talk about. Let's talk a little bit about, I'm going to skip mediation briefs for now, or maybe I won't. Mediation briefs. So if we're talking about settlement conference briefs, the way it used to be in Orange County was we would show up, the temporary judges would show up on a Friday. And you'd walk into the courtroom, the court would hand you a file, and you'd say, you'd call the name of the case and take everybody down to the cafeteria. In Orange County, as those of you who practice there would know, you have these settlement conference statement forms that are pretty meaningless. They don't really tell you much. And occasionally people have attachment to them or settlement conference briefs. The settlement conference judges, I as one, and the one who's done more than anybody, rarely ever read the briefs of the settlement conference statements prior to sitting down with the parties in the cafeteria or in one of the conference rooms. I've spoken to many of the temporary judges about this. In fact, I'm one of the trainers of the temporary judges in Orange County, and most of the temporary judges do not read the MSC statements or briefs, at least in Orange County, prior to sitting down with the parties. Now, sometimes this does not make the parties happy, counsel happy. They'll tell me, that I'll sit down with counsel, just counsel, but so tell me about the case. Plaintiff, tell me what's going on here, and I'll have all counsel there. And the counsel will say to me, "It's in my brief." And it's in my brief. I say, "Okay, great. That's great. I understand that. Just tell me about it. I'll get your brief." Well, it's all there, and they'll argue with me about it. And I'll say, "Look, just tell me who's suing whom for what." As far as briefs in mediations, those I do read. I'll go back for the settlement conferences for 1 second. In the last 2 years, I have done about 200 remote via Zoom settlement conferences. What's interesting about that process is that the clerks send you the settlement conference statements and briefs in advance. They'll send them to you on Wednesday or Thursday or whatever for the MSC on Friday. So unlike the old practice where we're in the courthouse and they hand the file, I actually do read the settlement conference statements and briefs in advance now. As to mediation briefs, the number one thing I would urge is be brief about mediation briefs. I get mediation briefs that are 25 pages long with literally 500 pages of attachments. And there's no way that I think probably any other mediator reads all that stuff prior to the mediation. A straightforward brief that tells about what the case is about, where the case is procedurally, and what the settlement what your strengths are, what your weaknesses are, and what the settlement negotiations are is perfect. And that's what I look for. If there's secret stuff you want to tell me, and I suggest exchanging briefs also, is that if there's secret stuff you want to tell me, put it in a separate brief or in an email or a separate letter to me. But it's best to exchange briefs, and I encourage that also when I get the briefs in a mediation, and they haven't been exchanged. That's one of the first things I'll ask counsel. Have you sent your brief to the other guy? No. How about if I do that? Well, they haven't sent me this. Look, if I get them to agree to give you your brief, will you give them theirs? Most of the time they agree. Sometimes they don't. Okay. Another thing that I want to talk about is no plaintiff demand. No chance for the defendant or the insurer to evaluate. This is always amazing to me when I find out that the plaintiff has not communicated a demand to the defendant and yet wants the defendant to pay significant money. This rarely leads to settlement, especially when you have an insurer or risk management on the defense. They need to run big demands through the committee or their supervisors or do their own analysis and cannot do it on the fly at a mediation. So that's a very common phenomenon where there is no demand prior to the mediation. This happens a lot in settlement conferences too, even when the settlement conference rules require, the Orange County rules require that I think 5 days before the MSC, the defendant or the plaintiff must make a demand and the defendant must respond to that demand. I mention that all the time and find out so many times that no demand has ever been made, although the people always refer to their 998s if those are outstanding. New evidence first presented at a mediation. And this is the kind of the same thing with no demand. I am told of new evidence, or no, I'm told of evidence that the plaintiff or the defendant wants me to tell the other side about. This is a new fact. It's completely determinative. It's never been mentioned before. And when I say it's a new fact, it may not be. It may be something the party has known for a long time, but the other side doesn't know it. And now the plaintiff in particular wants me to tell this new fact for the first time ever to the defendant at the settlement conference or the mediation. And what happens is opposing counsel just can't take your word for it. This is just like a demand, a new demand at the settlement conference and the mediation. They've got to do their due diligence. I mean, I've had this happen to me as a lawyer many times where I'm told something at a mediation or a settlement conference that would just destroy my case. And I say, okay, well, that's great. We never heard of this prior today. They haven't disclosed it in discovery. We haven't found it. And now they're telling me that I should pay them $2 million because of this fact. I can't do that today. I mentioned liens already. We talked about that. Normal restraints missing, and vengeance. I want to talk briefly about those. These are, and no skin in the game. No skin in the game, normal restraints missing, and vengeance. These are all related obstacles to settling. Imagine a defendant who is fully insured, who has already used up his deductible or copay or retention, and whose consent is necessary to settle. Sort of like medical malpractice cases in a way, or a person who has all the time in the world and truly does not care about the time disruption of a lawsuit, or vengeance. There's a party that's rich enough to do it and they just want to get even. I had such a case. It was 5.5 years of litigation that involved 4 separate trials. It was not bifurcated or trifurcated, it's quadricated in complex in Orange County. I represented the defendant who was a 32-year employee of the plaintiff, sued for usurpation of corporate opportunities and malfeasance. We tried the usurpation case first. It was several days. This was a court trial, actually. And we won. They had asked for $3.5 million. They got zero. The court found that he had not usurped. My client had not usurped corporate opportunities. Tried the malfeasance next. Plaintiffs had asked for $7 million. So plaintiffs were the persons who owned the company that my client had worked for 32 years. My client and the plaintiffs had been best of friends. They had built their houses next to each other. They'd done many, many things as families together. But my client went and opened some completing businesses, which he was allowed to do by his employment contract, as the judge ruled in the usurpation case. And this so angered his friends that they immediately fired him and sued him. So in this malfeasance, they were claiming that he had used corporate assets in his own business. The plaintiffs asked for $7 million. We tried this over 5 or 6 weeks in the Orange County Superior Court in complex. Plaintiffs, I think had asked for $7 million. They won. They won $118,000 on their $7 million claim on some weird theory that the judge came up with as to why he should reimburse them for my client should reimburse them for some of his salary. Their plaintiff's attorney's fees claim was rejected. The court found they were not the prevailing party. From that motion, we learned that they had spent $7 million in fees and costs on this case, but they won the case, and that my client had spent his entire savings and borrowings over $2 million defending himself. We actually had 2 mediation sessions in which they demanded the full amount that they were asking for and never lowered that. They wanted vengeance, and they got it in the form of ruining my client. As an aside, take a look at Corporations Code 317D, as we were able to get back my client was able to get back $650,000 in fees from the plaintiffs in the 4th trial, which allows you to sue a corporation who sued you if you're an agent of it and be indemnified. Let's see what else I've got here. A few other things to talk about. Let's see, next page, more to talk about? No. A B&P code, or B&P code 17200 and PAGA claims. I found them to be pretty valueless and adding very little value to any settlement discussions I've ever been involved in. I've probably mediated 20 to 30 PAGA claims, and I'd say in every single one of them, the PAGA claims were dismissed and the individual clients' claims were settled. And I know that's not the case in all of them. The same thing with B&P code 17200. As I said, I find they rarely add value to plaintiff's claim. The media's proposal. Now, media's proposal, I've got some quotes here you can read later, are frowned upon by high-powered mediators and by academics, and they attack both the mediators. I define the proposal as the exact point where the mediator ran out of skills. They also attack counsel. Unfortunately, I think many counsel looking for a media's proposal are more lazy than savvy. I completely disagree with that. Mediator's proposals work. They are often requested. Mine are based on the art of the possible. I take a look at that, and I tell that to the parties. And I'm not looking at the merits. I'm not looking at the law. I'm looking at what I can get done today, how low I can squeeze you down, plaintiff, and how high I can squeeze them up. And and I explain to them how they work, and then the other side's not going to know if you don't agree. But if you agree, we get the case settled today. Take a look at Green Tree versus Financial Group versus Execute Sports. Green Tree Financial Group versus Execute Sports. This is a case from about 10 or 15 years ago now, where the court basically said that you cannot have a stipulated judgment higher than the settlement amount because that constitutes an invalid penalty, invalid liquidated damages. There's been some subsequent cases to that, and this is something I encounter all the time, especially in mediations with counsel. There's going to be a payment. They're going to stipulate the payments, and there's going to be a stipulated judgment. And plaintiff's counsel wants the stipulated judgment to be the full amount of their claim. They're stipulating for a payment of $250,000, $10,000 a month for 25 months, or $25,000 a month for 10 months, whatever it is. And there's going to be a stipulated judgment, and if the defendant misses a payment, judgment will be entered. The plaintiff wants that judgment entered for the full $1 million. And I discuss this with them, and they say, "Oh yeah, I'm aware of that case," but then they tell me all the reasons why what they want is going to be okay. And I just find them so much. I say, "Well, okay, if you're comfortable with it, if defendant is comfortable with it." That's okay with me, even though you may have some problem. When I'm doing this in MSCs, I'm a little bit more strict about that. I make it clear that they understand that I don't think their particular amounts they're agreeing upon are going to be enforceable. And some of the judges, now other temporary judges take different approaches. And some of the actual judges, the real judges, don't sort of pay attention to Green Tree, and they'll enter what the parties want. Others will not do that. Let's see. CCP 664.6. This used to be a bigger issue. Now it's not. It's quite as important because it used to be that the parties had to agree to or had to ask for it, and now it can be done by counsel. Prohibited settlement terms. Take a look at those when you get a chance. Here are what I believe the keys to a settlement, from my perspective, are rapport and persistence. I do everything I can to develop rapport with both counsel and with the litigants. And how do I do that? I just talk. And I talk to the litigants about where they live. And now on Zoom, it's kind of cool because you can see into their homes and you can see artwork and you can see the grandkids running by and the dog and all that. But I'll talk to them about where they live, where they went to high school, whether they're a Rams fan or a Packers fan like I am, whether I'll talk to them about Cal football and how terrible it is, or anything else about the trees that I'm interested in. And I'll find some common ground and we'll and develop some rapport. I think that's essential, at least to my style of mediation. And the other thing is persistence. I mentioned that on Monday, I had a half-day mediation and we went 9 hours instead of 4 hours. It was set for. I just don't give up. The process works, the dance works, the bidding back and forth, and all that works if you go through it. And it's remarkable how many times parties who told you that they would absolutely not settle do settle, and how they also tell you this gap is too big. There's no way we'll ever close this gap. We do close that gap. So that's it. Thank you. I don't think we have any time left for questions today. You can, let me see if I have a slide with, there's my contact information. You can go ahead and give me a call. I'm delighted to talk to anybody who wants to call, or email me at ADR Services if you have any questions or comments. I'd be delighted with questions and comments. As I said, this is not a science. This is an art, and as I said, an abstract art, and I'm still learning it as much as all you guys are out there. So Hayward, I don't know if you appeared again, but thank you, and help get me out of this so I can shut down my PowerPoint and my share screen. I guess I'll stop share. How about that? There we go.
Thanks, Mike. Thank you, Mike, and thank you all for joining us.